Yes, Mr. Seagull.
Ladies and my lord, one final point on contractual construction by way of response to a new argument of the respondents. It notes that the courts have held that the terms of written employment contracts may need to be supplemented from other written or oral sources, cases like AutoCleanse and Uber. However, those cases are confined to situations where the obligation of the parties to each other have been incompletely, or as is the case in those two authorities, misleadingly included in a written contract drafted by an employer who has superior bargaining power, in circumstances where those other written or oral sources support the parties having actually undertaken additional or different obligations to each other. Put another way, where the way in which the parties' relationship operated in practice was not consistent with the terms of the written contract. And actually, it's interesting if we consider the basis on which those cases were decided. As the judgment of this court in the Uber case made clear, the exercise that the court carries out in these employee status cases is not, by contrast with subsection 2 of the 99 Act, one of the proper construction of the contract. It's quite the reverse. Can I ask you to go to page 870 within the judgment of Lord Legate on behalf of the court, picking it up at paragraph 68, referring to the earlier AutoCleanse case. The judgment of this court in AutoCleanse made it clear that whether a contract is a worker's contract within the meaning of the legislation is not to be determined by applying ordinary principles of contract law. He enumerates some of those. Not only was this expressly stated by Lord Clark, but had ordinary principles of contract law been applied, there would have been no warrant in the AutoCleanse case for disregarding the terms of the written documents which were inconsistent with an employment relationship, and then skipping to the next paragraph. Critical to understanding the AutoCleanse case is that the rights asserted by the claimants were not contractual rights, but were created by legislation. Thus, the task for the courts was not, unless the legislation required it, to identify whether under the terms of their contracts AutoCleanse had agreed that the claimants should be paid at least the national minimum wage, etc. It was to determine whether the claimants fell within the definition of a worker in the relevant statutory provisions so as to qualify for those rights, irrespective of what had been contractually agreed. In short, the primary question was one of statutory interpretation, not contractual interpretation. And then at 873, at paragraph 76, once this is recognised, it can immediately be seen that it would be inconsistent with the purpose of the legislation to treat the terms of a written contract as, note even, the starting point in determining whether an individual falls within the definition of a worker. So far from those cases being any sort of analogy or point of comparison with the present case, they stand as express exceptions to the general rule that the material obligations must be determined on a proper construction of the contract. Put another way, as I imagine my Lord Reed will recall, the employer's argument in Uber and cases like it is that the statutory definition of worker should be applied as though it provided for the question to be determined solely on a proper construction of the contract. That was what the employers were arguing in AutoCleanse and in Uber. And it was because this court refused to read into section 230 of the Employment Rights Act the words on a proper construction of the contract that the claimant succeeded. In the present case, by contrast, whether it appears that the parties to the contract did not intend the terms to be enforceable by the third party is expressly under the statute to be determined only on a proper construction of the contract. So, summing up in relation to grounds 1 and 2, we say that the majority of the Court of Appeal, having, I can't say ignored the early authorities, but certainly not having expressly taken them into account, misunderstood the statutory test, therefore asked themselves the wrong question, and having done so were forced, in effect, to answer it by misapplying the principles that govern the interpretation of contracts. Ground 3 of this appeal only becomes relevant if the court is against us on the first two grounds. It addresses the question posed by the majority of the Court of Appeal. If one must infer a joint intention from the background facts whether or not the check-off term was enforceable, what Lord Justice Lewis called the ultimate question, what is the appropriate inference? And we say, even on that basis, the majority were mistaken in construing a joint intention that the check-off term would not be enforceable by PCS. Now, this third ground of appeal raises what is essentially a factual question, albeit one of inference based on primary facts, whether, based on the background circumstances, one can objectively infer a joint intention that the check-off term should not be enforceable by PCS. And as to that, the trial judges in these three cases considered all of the factual matters relied on by the majority in the Court of Appeal and relied on by the respondents before you as supporting that inference. First, that the check-off term had been likely negotiated as part of a collective agreement which was not enforceable by the union. Second, the relative benefits to employees and union of the check-off term. And third, that the employers also agreed to make deductions in favour of other organisations. And the trial judges held that those background factual matters did not support an inference that the check-off term should not be enforceable by PCS. And that being so, we submit that the Court of Appeal could only legitimately interfere with that inferential factual finding as to joint intention if it was in effect perverse. It's not suggested they took irrelevant matters into account or left relevant matters out of account. We say it was not. So turning to those three factual matters, the first is summed up, if one goes to page 268 in the judgment of Lord Justice Lewis, at paragraph 82. He projects back to the presumed collective negotiations between the unions and the government in the 60s, and 6 lines down states this: the context, therefore, was not in truth a situation where the parties to the contract of employment were seeking to confer a benefit on a third party. My lord looks troubled.
No, please.
Oh, sorry, I apologise. I didn't want to interrupt an important train of thought, as it were. Now, we say that that is counterintuitive and contrary to the evidence. As we've seen, not only in the 1960s, but right up to date, Chekhov, well, I suppose I can only speak to up to 2014, Chekhov was seen by the government as primarily conferring a benefit on unions. That's the common situation. If an employer recognises a trade union and has good industrial relations with it, it will often provide Chekhov in order to make it easier for the union to recruit and serve its members. And civil service employers constitute a paradigm example. Ladies and lords, each of the individual claimants in these cases was given a statement of their main terms and conditions. Mr. Cox's is at page 402. They all include, in this document it's at page 405, at paragraph 15, the statement: there are various trade unions which can support an officer in reasonable claims and represent points of view on all kinds of questions affecting welfare and terms and conditions of service. The civil service attaches importance to effective consultation and involvement of staff. It is, of course, a personal decision whether or not to join a trade union, but we encourage staff to join an appropriate trade union, and to play an active part within it. It's in pursuit of those aims that employers offer check-off to union members within their workforce. Now, that part of each individual claimant's main terms and conditions was relied on by the first instance judges. I won't take you to, but an example is at page 293 at paragraph 16 within the judgment of Mr. Justice Chowdhury and Cox, but is not referred to in the judgments of the majority of the Court of Appeal. It's unclear precisely how and when the check-off term first became contractual. But what is clear is that in order for that to have happened, the employers and the unions must objectively have agreed that it should be a contractual term. And at that time, many years before the 99 Act came into force, no question of third-party enforceability of that contractual term could have arisen. However, if one were to be entitled to project back in time to infer an objective intention of third-party enforceability before that was legally possible, we suggest that the answer to the question, what would the employees and the employers have intended, is that they would have intended the unions to be able to enforce the obligation to provide check-off. And if it is right that the intention of the union negotiators should be attributed to the employees in the 1960s, then given that, and given the unswerving support of government to active trade unionism, and its decision as part of that support to, and I again quote the Cabinet Office, provide check-off as a service to certain trade unions, then surely the objective inference as to joint intention is that once incorporated as a term of contracts of employment, the check-off term should be enforceable by those unions if the law allowed. And we say the majority's contrary position is not only factually mispremised, it is conceptually flawed and chronologically incoherent. It's conceptually flawed because the fact that a union couldn't enforce terms of a collective agreement against an employer doesn't negate an intention of parties to the contracts of employment or their union negotiators that the union should be able to enforce what does become a contractual term which conferred a benefit on it as an identified beneficiary. So it is to compare an apple with a pear, but it's just a non sequitur. We say it's chronologically incoherent because it focuses on contracts made in the 1960s before the 99 Act was in force. Whereas, as my lady has pointed out, the only relevant contracts in these cases are, pursuant to Section 10 of the Act, those entered into after May 2000. Now, first, as a matter of fact, there is no finding and no reason to believe that employees entering contracts of employment after May 2000 would even have known or assumed that the check-off term derived from an unenforceable collective agreement made decades earlier. But the key point is that the relevant intention to infer, if we are going down this track of simply effecting an intention, the relevant intention, is that of the parties to employment contracts entered into after the 99 Act was in force, in circumstances where third-party enforceability was not only possible, but in the material circumstances of these cases where the term conferred a benefit on identified unions, was presumed. And in that circumstance, it is not sensible to attribute to the employees a supposed intention of union negotiators 40 years earlier in relation to the collective agreement. So we say that there is no sensible basis in addressing the hypothetical question the majority asked themselves on which to infer a joint intention that check-off should not be enforceable by the unions. In that regard, we would respectfully adopt and in one respect supplement the analysis of Lord Justice Stuart Smith at page 275 in the last 5 lines of paragraph 108 that my Lord Reed was pointing us to earlier. Put simply, The fact that the check-off obligation was not enforceable by PCS whilst it remained in the sphere of being merely the product of a non-enforceable collective agreement tells us nothing about whether the employers and employees intended that it should not be enforceable by PCS once the parties had chosen to include it as a contractual obligation which purported to confer a benefit upon PCS.
You say it's irrelevant that it was agreed under a collective agreement?
It's irrelevant to construing the intention once it becomes a contractual term. That is what, well, certainly what Lord Justice Smith says, and it's what we say, yes.
Can I raise here the point that was puzzling me a moment ago? If what one's dealing with is the construction of a contract, then the proper construction of a contract is a question of law, and appellate courts can therefore reach their own conclusion on it, untrammeled by lower courts. But you introduced your discussion of this. I think, and you may well be right, you say ground 3 raises the factual question whether one can objectively infer a joint intention that the term should not be enforceable by the claimant. Now, if it's properly characterised as a factual question, what intention can be inferred from the surrounding circumstances, then we're in a different ball game altogether.
Well, precisely.
And we have the finding of the judge on page 312, his discussion of it, and I wonder.
Well, it goes back to a question.
That should be the starting point rather than the majority of the Court of Appeal.
Well, precisely, but it goes back to a question, and forgive me, I've forgotten which member of the court asked it of me, but it was, the question was, were they not construing the contract words to the fact? And my reply was, just because you say you're construing a contract doesn't mean you are construing a contract. And so what I say is that what the majority of the Court of Appeal were doing in making that factual inference was not construing the contract, but seeking to effect, or if one's to be more charitable, identify the objective joint intention of the parties based on primary factual circumstances. So at no point, I say, does what they do actually constitute the construction of a contract, and therefore we say we are entitled to rely on what the trial judges concluded on that point, as opposed to what the majority of the Court of Appeal did. But obviously what I've said since then is addressed to the first principle task, as it were. We say it's the wrong task, but why we say the first instance judges got it right. And I said I would add, if I might, one sentence or clause to the end of paragraph 108, where Lord Justice Stuart Smith says it tells us nothing about what the parties intended when it was to be included as a contractual obligation, or as my Lord Borough said, it was irrelevant to that inquiry. We would add, more particularly, since we are concerned with the intentions of contracting parties after the 99 Act was in force. And that makes a very big, I would say, determinative difference. The second point principally relied Lord Justice Lewis alone, is his characterisation of the check-off term as the provision of a facility to employees. That is to identify a distinction without a difference. Recognised unions negotiate contractual terms for the entirety of the relevant part of the workforce, members and non-members alike. By definition, check-off only has effect in respect of those employees who are also union members. But even if there had been an explicit agreement between employers and unions that the check-off term was enforceable by PCS, the term itself as it appeared in the contracts of employment, those of union members and non-members, would still have to be articulated as a promise to deduct sums from wages and to pass them on to unions where any individual employee so authorised.
Can I raise another matter with you? I've been pinned down by Burrows on the proposition that the intentions at collective level are not relevant to construing or determining the intentions of the parties to the individual contracts. Now, according to the judge, that proposition is vouched by the case of Hooper in the Court of Appeal, and also by Harvey. We have a passage in Harvey in Lord Justice Stuart Smith, paragraph 113, but we don't have, I don't think we've got Hooper anywhere.
May I just say that I've asked for Hooper to be copied and brought for tomorrow because I wish to refer to it.
Right. Thank you.
I don't know on the Hooper particularly, as you know probably, the judgment of Lord Justice Stuart Smith in dealing with that passage says he's not sure that the reliance on Hooper assists or words to that effect. But can I just pick up on an important distinction of nuance, my Lord? I don't say that the intention of union negotiators is not or never relevant to construing contractual terms. On the contrary, I already conceded before lunch that it might well be. But that is not what Lord Justice Stuart Smith is saying here. What he's saying is that whilst it remained in the sphere of being merely the product of a non-enforceable collective agreement, tells us nothing about whether the employers and employees intended it should not be enforceable by PCS once the parties had chosen to include it as a contractual obligation.
Well, that means it'll never be relevant on your argument, because we'd only be in this territory if the parties had put it in a contract that expressly identified the third party and conferred a benefit.
But my lady, we're dealing here with an incredibly narrow subset of contractual terms. 99% of contractual terms that are agreed collectively and then become incorporated, I would concede it might be relevant, it depends on the circumstances of each case, but it might be relevant because you are there only concerned with the obligations of employees and employers. So let's take pay. The unions, that there have been cases where the courts have had to construe a particular term as to pay. It's been ambiguous. And the obligation, obviously, is on the employer. The beneficiary is the employee. So the question is, what did the employer promise to pay the employee? And in such a case, it might be relevant, and it has been held to be relevant, to consider what the intentions of the collective parties were. This is a tiny subcategory of case where we're not concerned with the obligation that the contracting parties owe each other, but whether or not that obligation is enforceable by the third party.
I mean, your point, as I understood it, when you answered it is irrelevant to my question, was on the question whether the non-enforceability of the collective agreement was relevant, and you say it's irrelevant.
Yes, that is
a separate question from the intentions of the
precisely so,
of the union.
When I mean, let us imagine that this was all happening in 2010 instead of 1960. So PCS sat down with the relevant government representatives and agreed check-off for the first time, and agreed that there would be a term in contracts of employment that was enforceable as such by employees, that the government would provide check-off for them. They would still, in 2010, know that as a collective agreement, it would be unenforceable by the union against the government. But it would be I was going to say a brave soul, but maybe I'm surrounded by brave souls, but it would, I suggest, be an unlikely inference that objectively the parties, the union and the government, and the employees, insofar as the union's intentions can be attributed to them, were at the same time saying that as a term of the contract of employment, it can't be enforceable by PCS. There is nothing, we agree with Lord Justice Stuart Smith, in that collective agreement to show that the parties intended anything different.
But aren't you then, isn't it susceptible, just stepping back to the argument that you are indirectly achieving what you couldn't achieve or haven't achieved directly? Of course, it could be achieved directly because you could put it all in writing, and then no doubt that part of the collective bargain would also be enforceable. But if you haven't done that, the normal starting point would be the law just does not enter into situations where there's enforcement by a union against an employer. It steers clear of that for reasons that we all know, that has been regarded as not the way that employment law is dealt with or collective bargaining is dealt with in this system. Now, aren't you indirectly undermining that if you allow this 1999 Act to give the union rights against the employer?
Well, my lord, I say not, but it's a big question, because in order to answer it properly, one would have to remind oneself what the rationale was for the non-enforceability of collective agreements, which I know this court considered in a case a couple of months ago, which has no application to this type of situation at all. But the shorter answer is, it is in no way inconsistent with the legal principle that collective parties cannot enforce terms of collective agreements to say that in the circumstances of Section 1, where a contractual term happens to identify a collective party and confer a benefit on it, that, well, as I say, it's not inconsistent that that should be enforceable by the third party.
I mean, I would have thought there are many terms in collective agreements not enforceable as between union and employer, which do, in a well-accepted way, descend into become terms of the individual contracts of employment, and is not taken to be an inconsistency between the non-enforceability of the collective agreement.
That's at the behest of the employee.
Yeah, there's no terms that are enforceable. As I understand it, there's no terms that are enforceable by a union against an employer.
Not unless they're expressed.
Yeah, not unless it's expressed. So that just doesn't happen.
Yes, but the reason, and this is why, with one eye on the clock, I say it's a big question, because the reason it doesn't happen, and we did explore this obviously at much, much greater length in the Nexus case, is because the courts have decided, or Parliament has decided, that it is not appropriate for terms that set out obligations as between employers and unions. So we will follow a dispute resolution mechanism as set out in Appendix 1, or we will accord
or check-off facilities.
Well, the check-off facility is
it isn't within
an obligation
the
to the
collective. Sorry,
no, it's my fault.
No, not at all. All I was going to say was, within the collective agreement, the union cannot sue the employer on the check-off agreement. That is not legally binding.
Correct.
So you are achieving indirectly, if you say that the third-party union is entitled to sue the employee, indirectly what could not be done directly or isn't being done directly. You could do it by making that part of the collective agreement enforceable by a written term to that effect, but without that, we have a system whereby the check-off facility is not enforceable between the employer and the union.
Yes, it first has to become a term of the contract, then it has to meet the conditions in subsection 1b and subsection 3, and then there has to be nothing in the contract that says that it's unenforceable. If all those boxes are checked, then I wouldn't personally characterise it as achieving indirectly, but you have a result which is different from the result without any of that.
Yeah, I mean, you might say that the policy of the 99 Act supersedes the policy.
Well, but the point I was inelegantly trying to make when you were referring, my Lord, to that well-trodden jurisprudence about, and legislation, about unions and employers not being able to enforce terms of collective agreements against each other, there is a mischief that's been identified. What we're talking about here does not offend, does not engage that mischief. It's simply saying that in this unique circumstance where the 99 Act applies, what was an unenforceable term of a collective agreement has become an enforceable term of a contract.
And there's a danger of a petition principii if you proceed from the premise that because an obligation is contained in a collective agreement, therefore, if it's transposed into an individual contract, it can never be the subject of enforceable under section 1(2).
Yes,
and it must, I mean, at the end of the day, you have to apply the statutory test.
Yeah, and we know from the Act as a whole that Parliament specifically envisaged that third parties would have rights of enforcement in respect of promises made by employers to employees. Now, I agree it doesn't say what sort of third parties, but there's a specific provision of the Act that says it doesn't allow terms in favour of the employer to be enforced.
That's one of the exceptions in Section 6.
Yeah. Exactly.
But you're if it can be that they could lawfully have agreed to make this bit of their collective agreement legally enforceable, then it may be no reason for saying that is what they have achieved indirectly, something that they could have achieved directly, and because of the way the contract of employment was arrived at and the way the Act works, they've done that.
Well, and again, it's hypothetical, of course, but 2010, they're sitting down in a room and some bright spark at PCS says, should we say that we need, that this ought to be enforceable by us? And an even brighter spark says, well, there's no need, is there? It's going to be a term of the contract of employment. It's going to confer a benefit on us. It's going to name us directly. We're not going to agree to anything in the contract that will disapply the statutory presumption that's set up by Section 1. We don't need to
Well, I think if they were a really bright spark, they would have done it expressly.
Well, it depends what they thought the reaction might have been.
Well, there'd be no issue then, would there? We wouldn't be here if there was an express term under the first limb.
Can I just then quickly deal with the other 2 points that we start, one of which is this business of the facility to employees. As I say, even if there'd been an explicit agreement between employers and unions, such as we were just canvassing, that the check-off term should be enforceable by unions, the term would still have to read in the same way. So there's nothing in the language of the term to negate an intention of third-party enforceability insofar as employees do authorise the deductions. It was simply the mechanism by which, as the Cabinet Office said, the employers provided the service to trade unions. And from the perspective of employees, as observed by Mr. Justice Popplewell as he was in Hickey, if one goes to page 678, last 7 lines of paragraph 24, any cost benefit to the union is necessarily a benefit to its members as such, and in their capacity as employees. It also seems to me an efficient and secure system of subscription collection for a union is in the interests of all its members. Each member benefits from the efficient and secure collection of dues from other members, and check-off benefits each member in that way. So, as it were, equating the benefits of members and union. And that being so, as Lord Justice Stuart Smith points out at page 276, 5 lines down in paragraph 11, a similar approach emerges from the majority's emphasis upon the benefits of the facility to the employee. So he's responding now to Justice Lewis's emphasis. Accepting that approach supports an inference, he says, and we respectfully agree, that even if the employers would not have intended the arrangements to be enforceable by PCS, their employees may have had a contrary intention because of the benefit it conferred on them. And I do note, by way of comparison, that the present case is much a fortiori to the Chudley case. The bank's promise in the letter of instruction to open a segregated client account constituted a promise to provide a facility to that customer much less directly for the benefit of the investors than the respondents promised in the present case. In Chudley, not only was there no obligation on the bank to actually pay monies to the investors, as there is in this case, it wasn't even required to inform them of the existence of the facility. The third and final point...
Sorry, just on paragraph 111, I just thought the observation there is also an answer to the officious bystander test insofar as there's any debate about that.
Yes, I respectfully agree. The last point relied on is, again, mainly, to be fair, by Lord Justice Lewis, is the fact that the employment contracts provided employers would make deductions in favour of a variety of other organisations if authorised. Now, it's important here to remind ourselves we are ex hypothesi applying the wrong statutory test, because otherwise the argument becomes viciously circular. If the employers were contractually obliged to pay authorised deductions to the Civil Service Insurance Society, for example, and if that term purported to confer a benefit on that organisation, which, as Lord Justice Stuart Smith pointed out, are matters of fact which haven't been addressed, then if we apply the correct statutory test, there would seem to be nothing in the contracts of employment to displace the presumption that the employers and employees intended that the insurance society could enforce that obligation, or put it the other way round, as Lord Justice Stuart Smith put it at page 276, at the top of that page, within paragraph 110. It is not a proper construction of the contract so far as it relates to the union dues, in my view, simply to assert that it's unlikely that the parties intended all such organisations were intended to be able to enforce the provisions. That asserted intent does not emerge from the terms of the contract, in which case, of course, it cannot help establish an intention of non-enforceability in respect to the Chekhov term. So that's what happens if you apply the correct statutory test. So it doesn't get the respondents anywhere. But even if we apply the wrong statutory test, then, of course, we are on an inquiry into background circumstances. We've got to inquire when, how, why, was it agreed that the contractual obligation to pay authorised deductions to the Civil Service Insurance Society arose? And of course, if we were to conduct that inquiry, it's almost certain, I suggest, that the circumstances would be very different to those in which the Chekhov term was agreed. The respondents can't have their cake and to eat it on this point. Either one applies subsection 2 according to the clear meaning of the words, in which case, ex hypothesi, if the test in section 1b is met, the Civil Service Insurance Society does have the right to enforce, or one adopts the statutory construction applied by the majority, and one must determine whether the parties to the contract would have intended that right of enforcement irrespective of the statutory presumption, based not on the terms of the contract, but on the surrounding circumstances, in which case the point of comparison is useless. So we say ground 3 must also succeed, even on the basis of their mistaken interpretation of subsection 2. The majority, we say, made the wrong inference of joint intention from the surrounding factual circumstances, and certainly, to come back to the point Lord Reid and I were canvassing, we submit they were not entitled to disturb the contrary inference reached by the trial judges based on the same factual circumstances. In finishing, if one steps back, it might perhaps be said that the approach of the majority in this case reflects in truth a concern about the operation of the Act. It's a concern which was identified in that article by Professor Burrows as preoccupying early critics of the Act at page 930, second line down. The real concern, I would suggest, is that one party, the promisor, might conceivably find itself landed with an obligation to a third party that it subjectively did not intend to undertake. that unintended liabilities in that sense are a risk of any contract given objective interpretation. We submit it is a concern that the employers in this case, in continuing to enter into contracts with their staff after May 2000, which included the check-off term, found themselves landed with an obligation to PCS they did not subjectively intend. And we know that because they didn't think they were obliged under the term at all. That lies, we say, behind the decision of the majority of the Court of Appeal not to apply the statutory provisions in these cases. I'm conscious I've taken 10 minutes. I asked my learned, well, I suggested to my learned friend, of course, that would come off the reply, and it would.
Thank you. Mr. Phillips.
May it please your lordships and your ladyships, I propose to make my submissions on behalf of the respondents under the following 4 headings. First, very briefly to summarise the respondent's case. Secondly, to deal with the significance of the employment context. Thirdly, to look at the relevant factual and industrial relations background. And fourthly, to make submissions on each of the 3 grounds of appeal. Starting then with a brief summary and overview of our case, we submit that Section 1(2) of the 99 Act requires the court to apply a straightforward test in determining whether, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by a third party. And we submit that that's a modified version of the dual intention test, the modification being simply that in relation to the second limb, intention to be enforceable, the burden of proof is reversed. Now, the inquiry under section, absent a case where there's an express exclusion of the 99 Act where there's nothing to argue about, the inquiry under section 1(2) arises ex hypothesi where the question of third-party enforceability has not been dealt with expressly in the contract.
But do you accept that it's only because of section 1, subsection 2, that an express exclusion takes effect?
Yes, but the Act could have said in section 1(2), it doesn't take effect if you've expressly excluded the 99 Act. It didn't say that. It's a much wider test, which just requires a simple inquiry into the proper construction of the contract, what the parties intended. And therefore, in our submission, the exclusion clause is a trite example of what will fall within section 1(2), because there's nothing to argue about. The more important question is what work section 1(2) does where there is not such an exclusion. And we say that whilst the burden of proof is on the party denying such intention, the test simply requires the court to determine the intention of the parties objectively ascertained. And the burden of proof does not necessarily have the decisive impact proposed by the appellants. Secondly, we submit that there is no basis for adopting a restrictive or artificially narrow approach to the construction of the contract. In particular, the construction is not limited to the circumstance of an ambiguous word or phrase. The entire relevant background and factual matrix should be considered, and the need to look at the contract in its proper context applies a fortiori in the employment sphere, where contracts are informal and piecemeal in nature, as they were here, and there's an important industrial relations background. Thirdly, we will submit that in the present case, the majority of the Court of Appeal were justified in construing the contract and in finding that it appeared that the intention was that the appellant should not be able to enforce the check-off term, and that all 3 matters relied on are significant and relevant. In particular, first, the check-off term was negotiated by way of collective agreement between the employees and the unions, which was unenforceable by the union and would have been clearly understood by all to be unenforceable by them. Secondly, that the check-off term was on its face designed to confer a highly beneficial general facility on the employees. It did not guarantee any benefit to any of the various third parties mentioned. Any benefit to the union was contingent and incidental to its primary purpose. And thirdly, that the check-off term enabled relevant employees to make deductions to a wide variety of diverse organisations, and it's inherently implausible that the parties intended either that that should be enforceable by all such members of that group or by only some subset of that group. So against that summary, I turn then to the relevance of the employment context. The notion of third-party rights is prima facie an anomalous one in the context of a contract of employment, such a contract being inherently personal in nature. And as Mark Friedland noted in his book, The Personal Contract of Employment, which we have cited, it's essentially a bilateral and personal one, a contractual relation between one person who's an employer and another person who is an employee. And although the 99 Act was excluded altogether for being used against the employee, we submit that some caution is required in it being used against the employer, even though it's not precluded altogether. We submit it's noteworthy that little, if any, consideration was given by the Law Commission to the particular features of employment contracts, in contrast, for example, to the position in relation to construction or insurance contracts. In fact, the only discussion relating to the employment relationship in the Law Commission report is in the context of insurance contracts taken out by an employer for the benefit of its employees, not in respect of the employment contract itself. And my Lord Burrows, in his 1996 article, refers to the Law Commission having to deal with specialist questions relating to bills of exchange, carriage of goods by sea, arbitration agreements, and the international carriage of goods by air and construction contracts, but not employment contracts. At the risk of stating the obvious, employment contracts are often very different in nature to the sort of commercial contracts that were considered in detail by the Law Commission. They may be wholly oral in nature, they may be partly oral, partly written, partly defined by the parties' conduct, partly determined by custom and practice, or by collective agreement. As Lord Hoffman put it in Carmichael and National Power, they may be contained partly in letters, partly in oral exchanges, and partly left to conduct over time. So such is the anomalous nature of employment contracts. And for that reason, we submit that this court has recognised that the usual limitations placed on construing contracts, although they are not particularly constrained in this context, those limitations themselves may be disapplied in the employment context. And I would briefly like to take the court, if I may, to Autocleanse and Belcher in the first instance. This case concerned workers who carried out car cleaning services but had signed contracts which stated they were subcontractors, and the Supreme Court held that the written terms should be disregarded because they did not reflect the true quality of the relationship between the parties. And Lord Clark said at paragraph 20, which is page 551 of the bundle, he said, the essential question in each case is what were the terms of the agreement. The position under the ordinary law of contract is clear. It was correctly summarised thus by Lord Justice Aikins in the Court of Appeal, and various principles are set out. But then at paragraph 21 on the following page, nothing in this judgment is intended in any way to alter those principles which apply to ordinary contracts and in particular to commercial contracts. There is, however, a body of case law in the context of employment contracts in which a different approach has been taken. Again, Lord Justice Aikins put it correctly in the remainder of para 89 as follows: but in cases of contracts concerning work and services where one party alleges that the written contract terms do not accurately reflect the true agreement of the parties, rectification principles are not in point because it's not generally alleged that there was a mistake in setting out the contract terms as they were. There may be several reasons why the written terms do not accurately reflect what the parties actually agreed. And at paragraph 33, Lord Clerk agrees with, this is page 556. Para 33, Lord Clerk says, as at para 103, Lord Justice Sedley in the Court of Appeal said that he was entirely content to adopt the reasoning of Lord Justice Aikins, recognising as it does that while employment is a matter of contract, the factual matrix in which the contract is cast is not ordinarily the same as that of an arm's length commercial contract. I agree. And then at 35, lower down the page, so the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what's been agreed.
We did spend a lot of time looking at this in Uber.
Yes.
And I haven't looked at it since. But my recollection is that we effectively expressed reservations about the reasoning in autoclants, and particularly the whole approach based on sham and snook. And,
Indeed.
And really, in the later case, in Uber, approached this whole sort of area of the law on the footing that where you were applying the EU legal protections for workers, there was a special statutory context.
Indeed, that's the next case I was going to go to, my lord. Uber
It wasn't applying ordinary contract principles.
Well, indeed, my submission...
That was because of the EU protection of workers being relevant.
Not on my reading of Uber, but I'll take you there. It's at page 853.
I may be mistaken. I haven't looked at it in a long time.
Yes, we submit...
Well, we looked at this in Deliveroo as well, I think.
We did indeed. And I wanted to take you first to paragraph 60.
What was decided was you're not actually looking at what the parties agreed. You're looking at whether what they do is a contract, whether they are a worker within the meaning of the legislation.
Well, with respect, in my submission, Uber does have something to say on the approach to construing contracts of employment. And to make that good, I'd like to take the court to paragraph 60 of Lord Legate's judgment, which is at page 868. He says at paragraph 60, in the Supreme Court, the sole judgment was given by Lord Clerk, this is in Autoclens, with whom the other justices agreed. In his discussion of the legal principles, Lord Clerk drew a distinction between certain principles which apply to ordinary contracts, and in particular to commercial contracts, and a body of case law in the context of employment contracts in which a different approach has been taken. And then we see the analysis of Lord Legate spelled out at paragraph 84, which is at page 875, where he says this about Autoclens. In the Autoclens case, it was said that the true agreement will often have to be gleaned from all the circumstances of the case, of which the written agreement is only a part. More assistance is provided by the decision in the House of Lords of Carmichael and National Power. And at the foot of the page, Lord Legate refers to Lord Irvine of Legg, where he says it would only be appropriate to determine the issue in these cases solely by reference to the documents in March 89 if it appeared from their own terms and or from what the parties said or did then or subsequently that they intended them to constitute an exclusive memorial of their relationship. The industrial tribunal must be taken to have decided that they were not so intended but constituted one, albeit important, relevant source of material from which they were enabled to infer the parties' true intention. In the Carmichael case, there was no formal written agreement. The Autoclens case shows that. In determining whether an individual is an employee or other worker for the purpose of the legislation, the approach endorsed in the Carmichael case is appropriate, even where there is a formal written agreement and even if the agreement contains a clause stating that the document's intended to record the entire agreement of the parties. This does not mean that the terms of any written agreement should be ignored. The conduct of the parties and other evidence may show that the written terms were in fact understood and agreed to be a record, possibly an exclusive record, of the parties' rights and obligations towards each other. but there is no legal presumption that a contractual document contains the whole of the parties' agreement, and no absolute rule that terms set out in a contractual document represent the parties' true agreement just because an individual has signed it. So pausing there, my Lord, Lord Reid, is right to say that Lord Leggatt went on to determine the issue in Uber by making the point that a purposive approach should be adopted to defining the relationship because it related to the application of a statute. But in my submission, the passages I've just taken the court to show that a much more open-textured and liberal approach to construction of contracts may be appropriate in the employment sphere.
Well, paragraph 68, which Mr. Siegel took us to earlier this afternoon, Lord Leggatt deals with this and accepts it in Auto-Cleanse. The judgment of the court in Auto-Cleanse made it clear that the issue wasn't to be determined by applying ordinary principles of contract law. But it then goes on to say what wasn't spelt out in the judgment was a theoretical justification for the approach. And then he goes on, Lord Leggatt goes on to explain that it was because the rights in question weren't contractual rights, but statutory rights, and therefore the issue in paragraph 69 wasn't what the entitlements were under the terms of the contracts, but how the statutory provisions were to be applied to the contracts.
Yes, I don't have any difficulty with any of that, my Lord, but all I make is the much more general proposition that if one reads what's said in Auto-Cleanse and what is said in Uber about the approach to construing contracts of employment, they make it clear that one is not hidebound by the same approach that one would adopt in the case of a formal commercial contract.
So you say, I'm not sure that's right, and I don't know why it would be right. I mean, why in theory would one approach one type of contract differently from another?
Well, for a number of reasons. One is that employment contracts, as in this case, are often informal and piecemeal in nature, and I'll take you to the employment...
So are commercial contracts.
Well, indeed, but if one reads, for example, the Law Commission report, that's clearly operating with a paradigm of a formally drafted employment contract. Secondly, the circumstances in which employment contracts come into effect are often ones of conduct and practice before anything is contained in writing. And thirdly, because very often one party is producing the document in employment contracts, and as here, the parties don't have legal advice as to how they're doing it. All of these factors...
You're saying that the government didn't have any legal advice?
In the sense that if one looks... I'll come to the contracts in a moment, but I would submit that there's no suggestion or evidence that these were drafted with the benefit of lawyers reading them. And indeed, it's not... It brings me to the next point, that for this very reason, there is statutory requirement to provide a statement of particulars of employment. And the reason for that is because so frequently there is no written contract of employment. We see the relevant statutory provision at page 490. Section...
But on your approach, clearly there will be some employment contracts where this is true and others where it's not true.
Yes.
In your submission, this is a general approach that applies to the whole category of employment contracts.
I'm making what perhaps is not a very radical point, which is that when one's dealing with employment contracts, it's at least as important to look at the underlying factual matrix and context and market as it is in the case of commercial contracts, and not, as my learned friend would have it, appropriate to adopt a restrictive view where one is excluding the background factual matrix. All I'm saying is that if one looks at the authorities on looking at the background to contracts, if anything, employment contracts are a fortiori contracts where looking at the industrial context is important. And that's as far as I'm taking the point. I'm not seeking to make anything more radical of it than that.
But I mean, just to press the point a little bit, I'd have thought in any process of construction of a contract, you have to identify what the terms of the contract are. So I take your point that there may be a number of sources to which one refers to identify the terms of the contract. But as my Lord points out, that's true in commercial context as well.
Yes.
But you still have to identify a term of the contract.
Absolutely.
I would have thought that it's not enough just to say, well, factual matrix. Factual matrix only allows you to fasten onto something which allows you to identify a term of the contract.
Well, that's right, but as I'll submit in due course, it's also a matter of looking at the underlying purpose, ambit, and intentions behind the contract, not simply a matter of looking at resolving an ambiguous phrase, which is what my learned friend says. In terms of section 1 of page 490, that requires employers to give employees a statement of basic terms in recognition of the fact that, unlike in other scenarios, often there would otherwise be nothing in writing. That statement is treated as persuasive but not conclusive evidence as to the terms of the employment contract. But we submit another illustration of the fact that in employment contracts, more perhaps than some other contracts, one has to be very careful before excluding relevant background. I turn then to the third heading of my submission, which is the relevant factual matrix. And we submit the following aspects of the factual matrix are particularly relevant and full to be taken into account in considering and ascertaining the objective intention of the parties in relation to the check-off term. First, it's common ground that the check-off arrangements were agreed by collective bargaining between the government and relevant trade unions, including the predecessor of the appellant, in the 1960s. At the time, both as a matter of statute and as a matter of universal and well-established industrial relations practice, the parties would have regarded the agreement as unenforceable by the union. The legislation in force at that time was the Trade Union Act 1871. By way of background, that act established for the first time the lawful status of trade unions, which previously had been regarded as amounting to criminal conspiracies and operating in unlawful restraint of trade. And the key aspect of that was to give them legal status for the first time. But in doing so, the Act also sought to exclude the jurisdiction of the courts in relation to various kinds of agreements entered into by trade unions. Section 4 does that, which is at page 481. Trade union contracts, when not enforceable, nothing in this Act shall enable any court to entertain any legal proceeding instituted with the object of directly enforcing or recovering damages for the breach of any of the following agreements, namely, and that's any agreement between members of a trade union concerning conditions on which members shall or shall not sell their goods, transact business, employ or be employed. And then 2, any agreement for the payment by any person of any subscription or penalty to a trade union. So just pausing there. At the time of this collective agreement, as a matter of statute, an agreement in relation to union subscriptions was unenforceable.
By the union against its member?
No, it says any agreement for the payment by any person of any subscription or penalty to a trade union. It's not confined in that way.
No, but would it include that a union could not sue its member for the subscription?
Yes. And that was all part of creating this sort of exclusionary space, because it was not desired at that time that trade union matters should be within the realm of legally enforceable obligations. Also of relevance is point 4, any agreement made between one trade union and another. That in practice operated to exclude collective agreements, because at that time, and this is dealt with in Roy Lewis's article, employers tended to enter into collective agreements through employers' associations, which fell within the definition of trade unions themselves. So it was a very, very particular and very, very, one might say, clear context in which this collective agreement was negotiated. And it's dealt with...
Sorry, at what point did the question of a union being able to sue a member for a subscription change, or has it ever changed?
Yes, so the 1871 Act was repealed in its entirety on its 100th anniversary by the Industrial Relations Act 1971. And I should say, my Lord, that there was quite a lot of case law in that century about which kinds of agreements could be enforced and which couldn't. So, for example, the courts would entertain a claim for wrongful expulsion from a union because that wasn't one of the types of contract that was specified in Section 4. But these types of contracts were not rendered enforceable until the Industrial Relations Act 1871. And the Donovan report provides some very helpful context and background to the position as it existed in the 1960s. The Donovan Commission sat from 1965 to 1968. It's at the extracts are at page 1051 of the bundle. And we can pick it up at paragraph 470 of the Donovan report, which is at page 1052. In this country, collective agreements are not legally binding contracts. This is not because the law says they're not contracts or that the parties to them may not give them the force of contracts. There is, in fact, nothing in the law to prevent employers or their associations and trade unions from giving legal force to their agreements. It's true that under a statutory provision, Section 4 of the Trade Union Act 1871, which is separately considered in Chapter 14, agreements between one trade union and another cannot be directly enforced in a court of law and damages cannot be recovered for their breach. An employers' association may be a trade union in the eyes of the law, and therefore a trade union and such an employers' association could not, if they wished, make their collective agreement enforceable directly or through an action for damages. They could, however, were they so minded, make it indirectly enforceable and, for example, obtain from a court a declaration concerning the meaning of the agreement. And then at 3 lines down, the fact is that nothing of this nature normally happens. That it does not happen is not, as we've already said, due to the law. It's due to the intention of the parties themselves. They do not intend to make a legally binding contract, and without both parties intending to be legally bound, there can be no contract in the legal sense. Then at 471, this lack of intention to make legally binding collective agreements, or better perhaps this intention and policy that collective bargaining and collective agreements should remain outside the law, is one of the characteristic features of our system of industrial relations which distinguishes it from other comparable systems. It is deeply rooted in its structure. So that was the summation of the Donovan report. And the status and nature of collective agreements was dealt with in even more detail in the decision in Ford Motor Company and Amalgamated Union of Engineering Workers, which is at page 643. And we submit this is a case which was heard in 1969, and we submit it provides an illuminating insight into the industrial relations environment in which the Chekhov term was negotiated. This was essentially a case where there were a series of collective agreements. The company sought to enforce a term of one of the collective agreements in relation to striking against the union, and the key point was whether the collective agreement was enforceable at all, and Mr. Justice Geoffrey Lane held the company had not made out a sufficient prima facie case that the agreements were legal contracts enforceable at law. And we can pick it up at page 654, where Mr. Justice Geoffrey Lane says at letter B, in the present case, there's no express provision by the parties to provide any assistance as to their intentions.
I'm sorry, did you say 654?
Sorry, that's 654, my lord.
Letter D?
Letter B. The judge says, in the present case, there is no express provision by the parties. Does my lord have that?
Yes, I've got it now.
I'm grateful. To provide any assistance as to their intentions. Consequently, it's necessary to look at all the surrounding circumstances to ascertain what the intention of the parties was. This, in my view, is not a case where, without further ado, the situation falls into one or other of the categories which I've mentioned previously. One must look at all the surrounding facts in order to discover what the intention of the parties were. And then if one goes over the page... But
this is their intention, whether they should have entered into a legally enforceable contract.
Whether the collective agreement was legally enforceable. That was the issue. But I rely on it really in relation to the general analysis, which begins on the following page. One sees at page 655 at letter B, the judge says, coming to the present day, or almost to the present day, one finds that the report of the Royal Commission on Trade Unions, in other words, the Donovan report, deals with this matter at considerable length. He then cites paragraphs 470 and 471, which I've already read to the court. And then over the page, at page 656, he deals with the evidence that was before the Donovan Commission. And this is above letter G at 656. It says, the matter does not stop there. Evidence was given before the Commission by the Confederation of British Industry, Trade Union Congress and others, and I've been given a photographic copy of part of the evidence of the Confederation of British Industry. And they say, for many years, employers have felt that the greatest single contribution which could be made to the better working of the industrial relations system would be better observance of agreements. They see, therefore, considerable attractions in any proposed changes in the law which would have this effect. So the CBI were in favour of a change in law and practice. If we then go on over the page to letter B, we see a copy of the written evidence of the Ministry of Labour was the effect that the common opinion is that a contract between a single employer and a trade union would also not be enforced by the courts. Oh, this is not specified by statute. And then, as has been pointed out, the contracts entered into between employers' associations and trade unions, and probably the contracts entered into between single employers and trade unions, are not legally enforceable in this country. And then one has at D the evidence of the Trade Union Congress, the TUC, and they say collective agreements themselves cannot be termed as contracts in law, as quite apart from the Trade Union Acts, the parties do not intend to be legally bound. The agreements are deliberately written in a way which would require radical amendment if this intention had been present. And then at paragraph 340, it cannot, however, be overemphasized that the effectiveness of obligations in this field does not depend on the existence of legal sanctions, but on the common interest of both sides of industry in operating an effective system of collective bargaining. Systems of industrial relations in different countries around the world show an inverse relationship between the practical significance of legal sanctions and the degree to which industrial relations have reached a state of maturity. And then at 341, the General Counsel are therefore firmly opposed to any proposal such as that suggested by the CBI to make collective agreements of whatever kind enforceable at law. This is not simply a question of administrative practicability, it is essentially a question of principle. Any such development would have a serious and damaging effect on the generally enlightened approach to industrial relations which has been evolved in this country over the years. It may be said in parentheses that perhaps Sir Keith Joseph and Margaret Thatcher wouldn't have completely agreed with them on that, and the law changed subsequently, as we will see. But the judge then says this is a synopsis of the evidence given by both sides of industry before the Donovan Commission, And the results in the shape of the unanimous Commission's report, which, as I see it, provided extremely valuable information, at least inferentially, as what must have been the intention of the parties as far back as 1955. There's then finally over the page a reference to other publications. I should deal with just two. The judge says first there's the Industrial Relations Handbook dated 1961 and emanating from the Ministry of Labour, HM Stationery Office. One finds this passage: the whole of the collective system rests upon the principle of mutual consent, and the value of the agreements and the machinery for settling disputes has depended upon the loyal acceptance by the constituent members on both sides of the decision reached. This acceptance is voluntary. Loyal acceptance has in fact been the rule in all the trade unions concerned. And then towards the foot of the page, before letter F, there's an academic contribution, reference to Professor Karl Freund, widely seen as the founder of academic employment law in the United Kingdom, and his article in the Modern Law Review, The System of Industrial Relations in Great Britain, which says, in the long history of British collective bargaining, it does not ever seem to have happened that either a trade union or an employer or an employers' association attempted to prevent the violation of a collective agreement by an action for an injunction or to seek compensation for an action in damages. The reason can certainly not be found in the absence of such violations. The true reason for the complete absence of any attempts legally to enforce the mutual obligations created by collective agreements can, in the writer's opinion, only be found in the intention of the parties themselves. An agreement is a contract in the legal sense only if the parties look upon it as something capable of yielding legal rights and obligations. Agreements expressly or implicitly intended to exist in the social sphere only are not enforced as contracts by the courts. This appears to be the case of collective agreements. They're intended to yield rights and duties, but not in any legal sense. They're intended, as it is sometimes put, to be binding in honour only, or which amounts to very much the same thing, to be enforceable through social sanctions, but not through legal sanctions. From the materials, it will be clear that the climate of opinion was almost unanimous to the effect that no legally enforceable contract resulted from the collective agreements. And so what we see is that it would have been well understood by all those involved in negotiating the Chekhov term in the 1960s that the collective agreement would not have been enforceable by the unions or by the employer for that matter. Collective agreements were regarded as lying outside the sphere of legal contracts and in the distinct realm of industrial relations. And by and large, the industrial partners, and certainly the unions, liked it that way. To complete the legislative picture, and this really deals with my Lord Sales's question, when the Heath government came to power, it essentially acceded to the CBI's position, repealing the 1871 Act after a century with the Industrial Relations Act 1971, which created a presumption, contrary to long-standing practice and understanding, that collective agreements would be binding unless stated not to be so. But interestingly, the law of unintended consequences then came into play, because that provision had exactly the opposite effect of that intended by the Heath government, because it became universal practice for the parties to collective agreements to state that they were not binding. That's referred to in the Roy Lewis article for your note at page 1049 of the bundle. The Industrial Relations Act 1971 was in any event short-lived. It was superseded when the Wilson government came to power with the Trade Union Labour Relations Act 1974, which effectively created the presumption of non-enforceability which we have to this day. And the up-to-date law on that is obviously Section 179 of the Trade Union and Labour Relations Act 1992, which is at page 489.
In fact, my question was directed to at what point a trade union could sue its member for...
Well, the answer to that would be in 1971, because that's when the 1871 Act was repealed in its entirety, and that provision was never reenacted.
Right. So what comes in later with Tolera and so on is just looking at the enforceability of a collective agreement as between trade union and employer. Is that right? So thereafter, the trade union is entitled to collect.
Yes. So, for example,
fees due under the contract.
If a member of a union ceases to pay, in theory, the union could sue him or her.
Thank you.
Just very quickly to look at section 179. It's at page 489 of the bundle. And this is essentially the way the law has stood since 1974. A collective agreement shall be conclusively presumed not to have been intended by the parties to be a legally enforceable contract unless the agreement A is in writing and B contains a provision which, however expressed, states that the parties intend that the agreement shall be a legally enforceable contract.
But there are also now various statutes which do give the union a right to bring an action against the employer, effectively on behalf of its members, to get a protective award of redundancy pay if there's been a failure of consultation, or under TUPE. I think there are those. So there are provisions.
Yes, there are specific statutory rights which can be enforced by the union, and equally the general statutory prohibition on suing by the union doesn't apply. It just applies to these collective agreements unless the presumption has been rebutted. But just standing back from this, we do submit that the context in which these terms were drafted could not have been clearer as to what the position would have been. And we submit that although we're dealing here with the incorporation of those 1960s terms into more recent contracts of employment, Lord Justice Underhill was correct to say in the Tyne and Weir Passengers Transport Executive and RMT case, and indeed in this case where he quoted his own judgment, that for these purposes the understanding and knowledge of the union negotiators who agreed the check-off term in the 1960s is to be imputed to the parties to the relevant contracts.
Why do you say that the relevant situation to look at is the situation in 1960s rather than the situation in post-May, what was the date?
2000.
Post-May 2000, because all these contracts presumably only came into existence after that date.
Yes, and the reason I say that is one has to look at the provenance of the term and the circumstances of its birth, if I could put it like that. And this is a term which was not, when we go to the contract, it's not referred to specifically, it's not discussed, there's no suggestion that it was when each individual employee entered into an individual contract of employment. But the origin of this term, its birthplace was the collective agreement entered into by the appellant's predecessors with the employer. And in my submission, it's at the very least permissible to examine the provenance and evolution of the term, but trying to understand the factual matrix.
Does it matter whether the employee realised that that was its provenance or not, or whether the current unions realise that that was its provenance?
No, because it's the subjective knowledge and intention of each individual employee is not determinative. What we're looking at here is the objective intention to be ascertained in relation to the check-off term. And in my submission, it is highly relevant in evaluating what the objective intention in relation to that term was, to look at the circumstances in which it was born.
I mean, surely, even when one's looking at objective intention, one's looking at the circumstances essentially known to the parties to the contract. I'm not sure that, well, speaking for myself, that objective interpretation of the contract means one goes back to the provenance of a term in very different circumstances, probably unknown to the parties to the actual contract that matters, which is the individual employment contract here.
I remember once acting for miners during the miners' strike in 1984 and asking to see a miners' contract of employment. And it contained documents going back, I think, before the First World War.
To which I would say that's all part of the factual matrix. And I would, in answer to my Lord Sales point, cite paragraph 32 of Lord Justice Underhill, in the Tyne and Weir Passengers Transport Executive and RMT case, which is at page 822 of the bundle, where Lord Justice Underhill says it's convenient to mention at this point that in his skeleton argument, albeit in a different context, Lord Hendy argued that a rectification claim against the individual employees would be unworkable, since it would be both impossible and meaningless to try to ascertain whether each of them had reached a prior agreement of the necessary kind. Mr. Reid pointed out that that submission was hard to reconcile with other aspects of the union's case, and I'm not sure that Lord Hendy meant to submit that not only the letter agreement, but also the individual contracts incorporating it were incapable of rectification. But if he did, I do not agree. I do not believe that the point about ascertaining the intentions of the individual employees gives rise to any difficulty. The employees have agreed that the terms in question should be negotiated on their behalf by the recognised unions. That being so, what matters as regards common mistake must be what the intended and expressed by the union negotiators, or as regards unilateral mistake, whether those negotiators had acted unconscionably in taking advantage of a mistake on the part of Nexus. Evidence about the negotiators' intentions and conduct can be adduced whether the defendants are the unions themselves or the individual employees, or both.
Do you accept this, at least, that if one has to look back at the 1960s for the provenance of the clause, one should also look at the circumstances of industrial relations in those days as set out in the Donovan report and in the Ford Motor Company, and see whether those still pertain today?
Well, if one does that, one's in roughly the same place by virtue of Section 179 of the 1992 Act. But in my submission, it's natural when looking at the intention underlying a term to look at the circumstances in which it was negotiated. And I'm making no more radical proposition than that. And that's indeed what Lord Justice Underhill said in the present case at paragraph 120 at page 279, where he cites his previous decision in the Tyne and Weir Passengers Transport Executive case and says, 4 lines down at the top of page 279, against that background, I believe it unequivocally appears that the common intention of the claimants and the appellants was that the right to seek check-off facilities should not be enjoyed by the union, on the basis that, as he says on the previous page, the correct analysis is that although formally the relevant intentions that of the employees as the parties to the contract in question, the intention of the negotiators who made the agreement on their behalf would be attributed to them. And in my submission, that's entirely a natural and commonsensical approach to looking at what was intended here.
I imagine it not be said that there are two potentially significant changes in, not sure if one calls it the factual matrix or the legal matrix, against which the current contracts of employment have been entered into. One is, as I understand it from what you say, since 1971, a union has a contractual right against its members to collect the fees, which it didn't have before. And secondly, we have the 1999 Act, and for the first time, the possibility of the enforceability by third parties of benefits which are purportedly given them under a contract between others.
Taking those in turn, it seems to me that the fact that the union can enforce a contract against its members is really neither here nor there in terms of whether the union can enforce a term against the employer. It seems to me that's a rather low-order point. In terms of the 1999 Act, in my submission, it is relevant here that there's a sort of sleight of hand in terms of how the appellants say that the employer becomes liable here, because essentially the term is negotiated when collective agreements are manifestly unenforceable and there's no such thing as third-party rights. One then gets contracts entered into subsequent to the coming into force of the 99 Act, which incorporate by reference in general terms the previous collective agreements, and the appellants say, bingo, we now have enforceable rights against the union. But in my submission, the very fact that these terms were negotiated long before third-party rights were a thing, as it were, tells against inferring when looking at section 1.2 that it was intended that the third party should be able to enforce them. It's a very unusual, it's interesting that the 99 Act specifically gave a 6-month grace period for people entering into new contracts to understand third-party rights and draft their contracts accordingly. The situation here is that because of a decades-old collective agreement, the appellants would have it that third-party rights were established by a sidewind. And in my submission, that's an extravagant conclusion which one should approach with caution when looking at section 1.2. Turning to the specific clause, where we haven't actually looked at the term yet that we're dealing with here, and to some extent this is lost in the mists of time, but we have the best versions or the most recent versions of the relevant terms in the bundle. We could start at page 388. Here we have the Civil Service Pay and Conditions of Service Code. And this version dates from October 1976. It's not that easy to read, but just about legible, I think.
Which page?
Page 388, my lady.
Oh, I've got something different there.
If one looks at the second paragraph, it says, within the civil service, the employer-employee relationship exists between the individual civil servant and his employing department. For convenience of departments, this code collects together the results of negotiations with employees' representatives and the rules for their application on all matters of pay and conditions of service which are handled by the Civil Service Department on behalf of all employing departments. And then if one goes over the page, one has, and the earliest version we have here is from 1987, the section on voluntary deductions from pay. And the terms themselves begin at page 390, the heading Voluntary Deductions from Pay, Introduction. This section sets out the arrangements relating to the voluntary authorization of deductions from the pay or pension of civil servants. Authority of deduction from pay or pension. A civil servant who wishes to authorize deductions from his pay for any of the purposes or organizations listed in Annexes 1 and 2 should obtain from the organisation concerned the standard form of authority approved by the Treasury, complete it and forward it to the organisation. And if we turn over the page to 391, there are some more detailed provisions, first of all relating to departmental sports associations. Deductions for a departmental sports association must normally be confined to one such association of a general character in each department. And then one has departmental benevolent funds. Deductions for a departmental benevolent society are permitted only in respect of officers serving the department named in the title of the organisation. And then there's insurance. Deductions may be made for the payment of premiums in respect of the life of a civil servant, his wife or children, including education and other endowment policies, the Civil Service Insurance Society, the Post Office Insurance Society, etc. And then at 4083, any other life assurance organisations not listed in Annex 2 may be granted deductions from pay facilities provided it can satisfy the Treasury it's carrying out a substantial amount of life insurance business among civil servants. And then over the page at 392, unions representing civil servants. Subscriptions to nationally or departmentally recognised unions representing civil servants may be paid by means of deductions from the pay of members. However, in the event of official industrial action by non-industrial civil servants and for the duration of such action, the method may be withdrawn. And then over the page, at page 394, we see the full list of potential recipient organisations, list of organisations for which deductions may be made free of charge. And there we see civil service, save as you earn schemes, like the savings scheme, national savings bank clubs, medical aid association, retirement fellowship, Saturday funds, sanatorium society, benevolent funds, Post Office Insurance Society, Civil Service Sports Council, departmental sports associations, and last, but no doubt my friend would say not least, nationally or departmentally recognised unions representing civil servants. And then under Annex 2, lists of organisations allow deductions for which a charge is made, and then a series of life assurance societies are there, although it's made clear in the earlier paragraph that that's not a closed list. And what we submit in relation to this is that...
You say that this is actually the clause that exists in a civil servant's contract of employment in 2024, is this clause?
Well, if one looks at the findings of the judges at first instance, it's a bit more complicated than that. Yeah. Essentially, what they do is they look at a patchwork of sources. This code, next they refer to the Civil Service Management Code, which essentially superseded it. And then they refer, within each of the three cases, to various departmental policies and handbooks. And what they say is, if one looks at this whole patchwork, this whole mosaic of materials, and the reference to incorporation in the Statement of Terms and Conditions, the check-off term is part of the contract.
But are all those other departmental policies and handbooks, are those also from the 1960s?
Well, we don't have a precise chronological sort of account of that. My understanding, my learned junior was involved at an early stage, is that the provision for deduction is in respect of benevolent societies and insurance schemes predated unions being included, which is why the unions are last in the list, presumably. But what I cannot provide, and I suspect nobody could provide in this remove in time, is a sort of chronological account of how this developed over time. I mean,
can I ask this? Is the check-off term included, you may have already told us this, included in the statement of particulars?
Only in a very general sense. I can show you the relevant documents for Mr. Cox at page 400.
Thank you.
So this is, in fact, the letter he received on the 15th of January 2002. I'm writing to offer you an appointment as an administrative assistant in the Home Office. You will be working for the Immigration and Nationality Directorate in Croydon. This appointment commenced on the 10th of September 2001. The attached schedule gives a summary of your main conditions of service as they apply at present. The summary, together with this letter of appointment, is issued in accordance with the requirements of sections 1 to 7 of the 96 Act. And then if one goes on to page 402, my Lord,
yeah.
It's heading Summary of the Principal Terms and Conditions of Employment. The following paragraphs summarise or refer to your main terms and conditions of employment. And then 4 lines down, details of civil servants' conditions of service are in the Civil Service Management Code, known as the Code, Home Office manuals, or where they have yet to be issued, the Civil Service Pay and Conditions of Service Code, and in the Staff Handbook. You should understand, however, because of constitutionalism, the Crown employees hold their appointments at the pleasure.
It doesn't come as one of these headings set out thereafter, does it? Check-off.
There's no specific reference to the check-off at all.
Okay, so
what we find it in the code, though, don't you?
Yes, there's reference to both codes. The second code, just to complete the picture, which is the Civil Servant Management Code, we have in the bundle, and at page 399, there's reference to voluntary deductions from pay.
And what is the date of that code?
That code, I believe, was coterminous with the devolution to individual departments of terms and conditions, which 1996.
Well, it's issued, paragraph 1 is issued under the 2010 Act.
Yes. Yes, but I understand that it first came in 1996, my Lord, and I think that's agreed. But that also refers to deductions from pay at page 168. And the way this was dealt with in...
I suppose what I'm driving at is when we're being asked to look at the check-off provision or term, we have to look at it from a range of different sources. It's and to that extent, it's across various potential documents, maybe summarised in the statement of particulars, but it looks as if that's just a cross-reference to the general other documents. Yeah.
Well, the position is, and this is why I say we're a very long way from the formal commercial contract that is discussed in the Law Commission report. Because if one goes to paragraphs 48 to 50 of Mr. Justice Chowdhury's judgment in Cox, he seeks to sort of encapsulate the contractual position, and none of this is in dispute. It says to the legal...
Sorry, which page?
It's page... give me one moment.
302, I think.
I'm grateful. Yes, I'm grateful to my Lord. It's page 302. So he says, in common with many civil servants, employees who commence employment in the decades that the individual claimants did a single comprehensive document purporting to be the contract of employment and containing all provisions in one location is not generally to be found. Instead, the terms and conditions of service are indicated in the summary to be provided with the requirements of sections 1 to 7 of the Employment Rights Act 96 and the other policy documents to which reference is made. The summary in the present case, which is in similar terms for all the individual claimants, unequivocally states that details of civil servants' conditions of service are in the codes, that's the two codes we've looked at, and in the staff handbooks. The Home Office handbook provides that a Crown employee working within the Home Office, the terms and conditions of employment of those set out in the letter of appointment, the Home Office handbook and the Civil Service Code, amongst other sources. The fact that these documents may not themselves be contractual does not preclude them from being incorporated. So,
I'm not sure we looked at the second code, but that's page 412 seems to be most directly relevant. And that's an undertaking to make deductions for direct payment to of trade union membership fees.
412.
What is page 412?
412 is the passport office. 2014.
My Lord, I understand, and this is why this gets so complicated. This is the Passport Office's manual,
right?
Dating from 2014.
Yes.
And therefore only applies to a subset of those in the Home Office case.
I see.
And again, it refers to trade unions, insurance and assurance societies, local hospital funds, etc.
I assumed we were being given Mr. Cox's documents as an example.
I believe you wasn't passport. Oh no, apparently he wasn't from the Passport Office, so that's
It's a key plank of your case, as I understood it, that although necessarily these contracts that are in dispute must postdate the 1999 Act, because you say this clause in that contract comes from the 1960s, when it was clear that collective agreements were unenforceable, that must mean that this clause can't confer third-party rights.
I wouldn't say it must mean. Well, not the way
all right, but
yeah.
that's a key plank of the reason.
It's a helpful indication.
Yeah, but what I'm getting from this is it's not at all clear that that's the provenance of any of the clauses that are in these terms and conditions at all.
Well, it's right to say that because of the complex factual circumstances, much of this is shrouded in mystery. Mr. Justice Chowdhury sought to develop this point at paragraphs.
But he rejected the relevance of the unenforceability of any relevant collective agreement. I mean, my understanding is that there are no collective agreements now.
Oh, there absolutely are. And to be clear, it's in no way essential to my case that this was a collective agreement concluded in the 1960s. It strengthens my case, as it does the fact that it predated the 1999 Act. But in my submission, the core argument here is because this undoubtedly has its origin in collective agreements negotiated with the union in circumstances where it was a cardinal principle that the union couldn't enforce it, it must at least be highly relevant as to whether the union can enforce it now by the back door by seeking to rely on the 19...
So can I ask you this? So let's take 6 months after the coming into force of the 1999 Act. And at that point, we are talking about an individual contract of employment whereby collective agreement terms have become incorporated because apt. So we're assuming that the check-off facility has become, it is apt for incorporation, has been incorporated. Now, at that point in time, as I understand your submission, you're saying collective bargains, collective agreements are not, at that point in time, nor have they ever, since 1960s, which this one is, in fact, before then, ever been enforceable contracts as between the union and the employer.
Indeed.
So, would I be right in thinking that do you go so far as to say that if you asked the parties, did you or did you not intend the 1999 Act that's just come into force to be applicable to give the union the right, would you go so far as to say that the answer would be, of course not? The officious bystander would say, that's ridiculous in a situation where the collective bargain itself is unenforceable.
Well, in my submission, that's not where we're at. But if that had been the scenario, in my submission, that would be the most natural inference, not least because, as my Lord has pointed out, it would be perfectly possible for more recent versions of collective agreements to say, this is the check-off term and it can be enforced by the union. And that would be perfectly lawful under Section 179. The fact that they have chosen not to do that indicates that it remains the union's position, as it was in the 60s, and it's essentially been ever since because they haven't sought to introduce a legally binding term, that those terms should not be binding as between them and the employer.
Okay. Now,
but we're not concerned with the union's intention.
Well, in my submission,
the critical question under Section 1 is the intention of the parties to the employment contract.
Indeed, but then I come back to my Lord Justice Underhill's point that for these purposes, the union's intentions are to be attributed to the employee. And that's the Tyne and Weir passenger executive case.
I realise that you're not necessarily putting the implied term, or what I would call negative implied officious bystander term, but you're saying, as I understand it, that you come to the same result, because what we're trying to do is to make sense of what this contract drawn from all these different sources that's been incorporated because those parts were apt to be incorporated, what we can derive from, as to the parties' negative intentions from trying to construe all that. Is that right?
Yes. And in my submission...
So where is the collective agreement from which the clauses in the contracts in dispute come from?
Well, I've shown you some of them. The point is that what we don't have is either the very first version from the 1960s.
No, I'm not. I'm looking at the collective agreement that was in force when these contracts were entered into.
Well, that's with respect, not how Mr. Justice Chowdhury analysed the point. If one goes to paragraph 49 of his judgment at page 303, what he said there essentially is as to whether or not the check-off provisions are apt to form part of the individual contract. One can consider specific language. It says, I begin with the root documents. And the root documents are, the CSPCSC, which is the first document I took the court to, the 1987 one, and the CSMC from 1996. And then he goes on to refer to a whole group of other handbooks and collective agreements. And where he ends up with all that is essentially saying, looking at the entire industrial relations background as set out in these collective agreements, I find that the check-off term is incorporated. But what he doesn't do, and with respect it would be impossible to do, is identify a particular version or a particular date which is the key one. The reality is what we have here is a term that's been continuously part of a whole series of collective agreements between the employers which change identity and the unions which change identity over a 60-year period. And looking at the totality of that, one reaches a view as to what the collective terms are. And what we submit from looking at that...
Can I ask you another question? Back on the 1999 Act,
yes,
1 subsection 2,
yes,
which is obviously the crucial subsection. Subsection 1B does not apply if, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party. On your submission, does it make any difference whether the words on a proper construction of the contract are there or not? Let's just assume for 1 minute that those words were not there. Subsection 1B does not apply if it appears that the parties did not intend the term to be enforceable by the third party. As I understand it, you would say, well, that would be totally clear, because you've not even got the process of construction. Does it then follow that you would go on to say, well, you can't possibly make so much of on a proper construction of the contract that it would defeat the basic idea that we're talking about the intention of the parties not being to confer a benefit, an enforceable right?
Indeed, and the reason I would submit that, my lord, is because the exercise of contractual construction is, at its basis, an exercise in ascertaining the intention of the parties. And we respectfully resist the suggestion from the appellants that because the words construction of the contract are there, one has to find an ambiguity or a particular phrase or word that has two meanings. Construing a contract is a much more multifaceted exercise than that. It involves at least 5 different things. It involves ascertaining whether there's intention to create legal relations in relation to some or all of the agreement. It involves ascertaining whether terms should be implied into a contract under the various methods of doing that, including custom and practice. It involves looking at the purpose of the contract, which has to be seen in the context of the relevant practice, industrial practice, market practice, commercial practice. It involves looking at the ambit of the contract. How far is it supposed to cover a particular scenario or not another scenario? It also involves construing ambiguous terms, but that's just a subset of what's involved in construing a contract. In our submission, my learned friend is really fastening onto a highly technical and reductive version of what construing a contract amounts to here. Because if he were right, unless you have an exclusion clause, there's virtually nothing to be done.
But I think I'm coming at it from the point that it would produce an absurdity under the Act, wouldn't it, if you produced a different result, if you crossed out on a proper construction of the contract from if you left it in?
Indeed. And in my submission, the suggestion that sort of is a completely different approach is nonsensical. And I think...
Are the words surplusage, or do they add anything?
Well, in my submission, there probably are surplusage, but they do at least indicate that the exercise one is looking at is one of contractual construction, where we submit my learned friend errs is in suggesting that that's a narrow exercise which doesn't permit one to look at the context, purpose, and background, which is what he's forced to do because the background's so unhelpful to him. And tomorrow morning, I will come to the 3 cases that deal with Section 1.2, Nishin Shipping, the Lambthong Glory, and Chudley and Clydesdale Bank. And I will be submitting that each of those cases looks at the relevant commercial and factual background in precisely the way that we invite this court to do so, by reference to practices in the shipping context and so forth that they deal with, and that the exercise that the Court of Appeal took in the latter 2 cases and Mr. Justice Coleman took in the first case would be prohibited on my learned friend's restrictive analysis of Section 1.2. And we see that's simply a gloss on the section, which is there to do something quite simple, which is to say if the term purports to confer a benefit on someone, then it will be enforceable by that third party unless, if you construe the contract properly, it seems that's not what the parties to the contract intended. And there's no justification for adopting a restrictive or narrow approach to that exercise.
Did I understand you correctly a few minutes ago to submit that where a term in the employment contract has its origin in a collective agreement, the intention of the union negotiators who are party to that collective agreement is to be attributed to the employee who's party to the employment contract?
Yes, my lord.
Yes.
And I think you cited a case, Tyne and Weir, something.
Yes, so that's the decision of Lord Justice Underhill, which perhaps I could just finish by returning to that, which is at page 810 of the bundle. And I believe some members of this court, at least, and my learned friend, have already some familiarity with this case. That was a case where the employer sought rectification of a collective agreement, and they sought rectification of a collective agreement, and the question was whether that was open, and there were various issues as to, well, is that available if, for example, third-party rights might be prejudiced given that rectification is an equitable remedy and so forth. But the key passage, which I've already taken the court to, is paragraph 32, where Lord Justice Underhill says, the employees have agreed, this is just over halfway down that paragraph, the employees have agreed that the terms in question should be negotiated on their behalf by the recognised unions. That being so, what matters as regards common mistake must be what was intended and expressed by the union negotiators, or as regards unilateral mistake, whether those negotiators have acted unconsciously by taking advantage of mistake on the part of Nexus. Evidence about the negotiators' intention and conduct can be adduced whether the defendants are the unions themselves or the individual employees.
And that was in the context of attempting to rectify the agreement.
Indeed. And what Lord Justice Underhill said in the present case on that issue specifically is at paragraph 120 of his judgment, he says, 3 lines from the foot of page 278, he says, for what it is worth, however, I think that the correct analysis is that although formally the relevant intention is that of the employees as the parties to the contract in question, the intention of the negotiators who made the agreement on their behalf should be attributed to them. CF, though the issue was not quite the same, Tynan Weir, Passenger Transport Executive and National Union of Rail, Maritime and Transport Workers. And just pausing there, in my submission, one often has a situation where terms of conditions are agreed by a trade association or a commercial organisation to be of general application, and they are then incorporated into consumer contracts or trade or commercial contracts. And in my submission, in all those scenarios, the natural way to approach that is to ascertain the intention of those terms that incorporate by reference by looking at the circumstances in which they were actually negotiated, not looking at them highly artificially in the context of a subsequent consumer contract where no one's looked at them, or a subsequent commercial agreement where they've just been incorporated as an aside. In my submission, it makes entire sense that in this context, effectively, employees ask the union to negotiate on their behalf, and where they do so, one attributes the objective intention of the union to them.
And I understood that Mr. Siegel had accepted that point.
As did I, my lord. I see we've just gone 4 o'clock. I hope that's a convenient point at which to pause, and we'll return to these matters at 10:30 tomorrow.
Yes, thank you, Mr. We'll adjourn then for the day and resume at 10:30.